I'm Kim Askew. I'm a partner in our Dallas office. I do all kinds of employment law, mainly litigation, and I'm joined by two of my other fabulous partners, Georgia Jolink. Georgia's from our Austin office. She does mainly global international transactions. My practice ends at the water's edge of the United States. That is where Georgia's picks up most of the time. And of course, Todd Mobley, who does a lot of transactional work and advises on so many transactions. We're going to talk about some employment hot topics and trends. What employers need to know. Some of these things you may not want to know because we know the reactions we get when we call you to tell you about some of these things. But we're going to try to move through this quickly, sort of as a survey, just so you know what the issues are that you need to be thinking about, and that if you haven't confronted, you probably will.
But we'll get to all that later. So to start, we'll start literally on the nose. With pay transparency and job postings is an area that has been developing quite a bit over the past few years and can be quite cumbersome and difficult to navigate when you're operating in multiple jurisdictions throughout the United States or the world. With respect to pay transparency laws, there are generally three buckets that they fall into. One is disclosure and job posting. So that's states that require you to, or jurisdictions that require you to provide wage and in some instances benefit related information in connection with the actual job posting itself. Affirmative disclosure states, which are states that require, not in connection with job postings, but that you provide wage or benefit information at certain points throughout the application or hiring process, usually at the time of offer or before the first day of employment. The last group is sort of the older group where, California and Washington were leaders in this area. This was their law. They've now moved to the first group, but it's jurisdictions where you have to provide wage or benefit information upon request by the individual. No, I just add that it is very difficult. So when you're operating, all these laws are of course very different. Colorado's law is requires one set of disclosures. New York's requires a different set of disclosures. What do you do if you have a remote position that someone could fill in Colorado or New York? Probably have to post two different salary ranges, additional information in Colorado. So it is a bit tricky. There is. There's a potential. They were trying to work on legislation in the House of Representatives on the federal level. So it would be pay transparency would be regulated at the federal level. I think we all know where that's headed, or not, at least anytime soon. So we're going to have to stick with the multiple jurisdictions and trying to navigate our way through those.
So can you all hear me okay? I think this is working. So throughout this presentation, I'll be sprinkling in the non-US perspective. And interestingly, we usually think of the EU as the leader on workers' rights, but the US has sort of gapped Europe in some respects with respect to pay transparency, and is now making a big push on pay equity in general with the prerogative of really creating equity for employees who do the same work or work of equal value. I'm going to skip ahead quickly just to introduce the new directive that was just enacted this summer by the European Commission. And this is sort of an omnibus directive. And for those of you who don't know what a directive is, essentially the EU Commission comes in and says, hey, here's some minimum guidelines that all of you EU member states need to implement. We're not going to tell you exactly how to do it, but you at least have to hit this standard. You can always do more. We encourage you to do more, but you have to at least hit this floor. So the directive does a lot of interesting things, and one of them is it requires pay reporting by all employers with 100 or more employees in a member state. This is going to start for large employers starting in 2027, and as you can see, will roll on for different sized employers after that. So it's definitely a new requirement. The big kicker is if there's more than a 5% disparity in pay between men and women who perform the same work or work of equal value, and it's not remediated within 6 months, essentially the companies are going to have to fix it. And not only that, they'll have to consult with employees, employee representatives, and other groups and put together an action plan. So Going back one slide, I mean, you can see it's sort of a hodgepodge now where we stand in terms of which countries even require some sort of gender pay reporting. The UK sort of got out in front of this in 2018, but as you can see, the red flag, I'm not sure if you can read it, the red flag denotes areas or countries where you actually get sanctioned if you don't comply. And the UK there's no teeth to its law, so even though it does require employers to publish data on gender pay gaps, it's just a name and shame issue more than anything. So now the EU is coming out and saying, not only are we going to make you do this, but we're going to attach pretty significant sanctions to it. As we know, the UK is no longer in the EU, so sort of remains to be seen if they'll, pass a copycat law or if they will sit pretty with their new name and shame law, or with their current name and shame law. So lots of movement in this area worldwide. Brazil also has a reporting law that's going to come into effect next year for those with more than 100 employees. So now over to Kim to talk about different types of equity.
Actually, could I say what, just
Yeah,
so everybody knows, also the EOC has pay equity on their new enforcement strategic plan that just came out. And I mean, they've been focusing on it for a long time, but once they put something on their plan, they go after it vigorously. So definitely something to keep an eye on and think about in the United States as well.
Yeah, absolutely.
I'm going to talk about the reforms in the wake of Me Too. Me Too is changing significantly, but there have been a lot of changes in both federal and many state laws, especially in the area of arbitration, non-disclosure, confidentiality, and non-disparagement. And we have a lot of severance agreements, settlements agreements, lots of agreements are already in place. We're entering into new ones, and we really need to have these in mind as we are entering into these agreements. The first one is the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. I call it EFA because that's quite a name there. It applies to any person bringing a sexual assault or sexual harassment dispute after March 3rd of last year, the date it went into effect. And this is significant because it actually amends the Federal Arbitration Act to allow a person bringing a sexual assault or sexual harassment claim, they allow them to proceed in court and basically invalidate an otherwise valid arbitration agreement. So just because you have an arbitration agreement that covers sexual harassment, sexual assault, we generally have very broad language covering any dispute that arises out of the employment relationship. Well, this act invalidates that, and the person bringing that sexual assault or sexual harassment claim, they have the option of whether or not they're going to go to arbitration or whether they want to be in court. They can go to court despite that arbitration agreement if that dispute arose on or after March 3rd of last year. And I won't talk about this a lot, but it also allows the person who is the representative class member to also invalidate our class action or collective bargaining waivers also that are in these agreements. So this is a pretty important law you really ought to be aware of. I'm sure many of you have already thought about that, amended various agreements. It has no retro application. Luckily, March 3rd on or before, if claims arose before that, they are barred. But keep in mind the continuing violation theory. There's a case that just came out of the Northern District of Texas, the Watson case, where lots of the claims are barred. What happens? One claim is within the statutory period, and the court says that arbitration clause is invalidated, and this case will stay with me. The other key takeaway from this is that the courts, everything is going to court. The arbitrators cannot make decisions on the validity or the enforceability of an arbitration agreement. It's taken away. Even if you have a delegation clause in your agreement that says the arbitrator makes these decisions, any court that it's in, and they're mostly federal courts, they're going to say, no, arbitrator, that's my decision. But remember the important thing here, you can still go to arbitration if the plaintiff chooses to go to arbitration. And of course, there are many valid reasons why a plaintiff may want the confidentiality, the efficiency, the speed of arbitration. But if they decide court's it, you will be in court. The other act that's important is the Speak Out Act. This one became effective on December 7th of last year. Again, it is not retroactive. It makes non-disclosure and non-disparagement clauses unenforceable, again, related to sexual assault and sexual harassment disputes arising under any federal, state, or tribal law. So again, quite broad, does not bar actions that arose after the effective date. So once again, a plaintiff can choose to enter into a non-disclosure or non-disparagement agreement. This is not a blanket prohibition on the use of non-disclosures and non-disparagement agreements, but it's the plaintiff's choice. And so you see the effect of Me Too in with these claims. They're going to a public forum and are not in the forum of arbitration. Lots of state laws are out there that are also restricting non-disclosure, confidentiality, non-disparagement agreements. Colorado, Virginia, Rhode Island, they all they redefine harassment, some of them. They limit employers' affirmative defenses, and of course they limit the use of non-disclosure and confidentiality provisions. So depending on where you are, you really want to take a look at what the law is in a particular state. I will also mention the NLRB decision that I think we're all familiar with now. That came out, I think it was February of this year, the McLaurin McComb, and then a few months later, the General Counsel of the NLRB came out with the interpretation. And basically, it does not ban non-disparagement and confidentiality agreements, but it specifically narrows it to specifically narrowly tailored agreements. We can no longer have those very broad agreements that cover everything. This memo, which again, it is not binding on us, it does not have the force of law. Some courts follow them, some courts do not. Some courts in the same district say yes, some say no, so it just depends. And I always say we are in the Fifth Circuit and we know what they often say about this type of guidance. It gives an example of confidentiality agreements if it's specifically tailored to restricting the dissemination of proprietary trade secret information for a limited period of time. I mean, you've got to show that there's a reason you're doing it. The same thing with non-disparagement agreements. If somebody says something that's just maliciously untrue, the words used by the General Counsel, with knowledge of the falsity or reckless disregard for the truth, try proving that, then yes, you can enter into a non-disparagement agreement. So this case is currently on appeal, I think, in the Sixth Circuit, moving quickly.
But that has not stopped the NLRB from already filing enforcement actions based on the GC's memo. So
keep going until a court clarifies what they can and cannot do here. I want to move very quickly to the D&I area because the diversity, equity, and inclusion issues are becoming quite challenging, especially in the light of the two companion cases that were just decided by the Supreme Court, Students for Fair Admission versus University of North Carolina and Harvard. And as you will recall, their race-based admission policies were challenged. We know what the court said. If it's based on race, race can't be that deciding factor. Of course, this was decided under the Equal Protection Clause of the 14th Amendment, and there's a lot of language used in there. We can't use race, unless there's a compelling government interest, got to be narrowly tailored. But the big thing, I think, what we want to talk about is how does it affect us? This was a decision in which state actors were involved. So the issue is, how does this really apply to private employers, to many of us in this room? And Given that it challenged admissions decisions, what does this mean for Title VII, for our diversity and inclusion programs out there, and what ought you, as representatives of your company, what ought you to be thinking about? Well, first of all, what legally changed after these decisions as it relates to what we do? Nothing. It didn't. Title VII is still Title VII. The law of Title VII, which prohibits race and all of those other discrimination or harassment on those protected characteristics, none of that changed. You still cannot provide or exclude benefits based on a protected category. We must still comply with all of our obligations to ensure that there is a safe work environment that's free of harassment. So why are we talking about this so much, besides the fact that, we care about what happens with admissions in education? And some of you may have received one of those 13 letters that came from the attorneys generals of 13 states, and one state senator from Arkansas joined in those letters warning companies that they would be taking action and looking at whether companies were using hiring preferences, quotas, whether they were giving preferences to contractors. So it is a cause for concern. And then on July of 19th of this year, attorneys generals from 20 other states and DC came out and said, wait a minute, that case doesn't apply to any of that. That case did not apply to Title VII, so you're just fine. We want you to think about the things that we have always asked you to think about. So the battle is really being teed up there. And we look at the issues and we try to just give some best practices for how you avoid the issues here. One, you just got to go and look at what your DEI programs are, just to ensure that whatever you're doing, that it does comply with the anti-discrimination laws. Title VII is still the law of the land. Unlawful quotas, making any employment decision based on race, gender, any protected characteristic is probably gonna give rise to questions. Review the language in your policies. Look at, first of all, it's an interesting decision to read, so it's worth doing it. And just remember that admonition given to us by the Supreme Court that diversity does not begin and end with those 6 EEO1 fact race classifications that are out there, that we can still look at a lot of other things. And training, it's always important to make sure that we're training and that we're using trainers and facilitators who really understand what's going on here now. So.
Okay.
Wage and hour.
Well, shocker. Wage and hour remains a risky area of employment law,
That's good.
to the surprise of no one, I'm sure. Of course, it's difficult for, compliance is difficult because you have so many competing jurisdictions to think about. There's the FLSA on the federal level, and then pretty much each state has its own wage and hour laws that can vary quite dramatically. It's also an area that lends itself to class, collective, and representative actions. So there's also that threat to think about. And also recently, something that's been happening is a lot of government agencies have been entering into agreements with each other to cooperate more, share information more readily. The DOL, the FTC, the NLRB, the EEOC, they've all entered into these agreements. And now we're getting into an area where you might have started with a wage and hour audit by the DOL. They uncover something that they find interesting, that the NLRB might find interesting, and now what was a wage and hour audit is becoming an audit of your confidentiality, non-disclosure provisions, or separation agreements, or things of that nature. So. Definitely an area to watch out for, as has always been the case. Just a couple of points on some developments in this area. One, technology, I think, is changing wage and hour law a lot. A lot of defenses that used to be readily available to employers may not be as effective anymore. The ability to track employees and to track employees' time makes it harder to make certain arguments that employers would rely on in wage and hour cases in the past. For example, there's a case on its way to the California Supreme Court where an employer had the ability to track employees' time by the minute, but they had a rounding policy in place. They rounded to the nearest 5 minutes. And so now that's being called into question because the employer had the ability to actually count, the actual time. Booting up, shutting down at this point, I think the de minimis argument is not going to be available anymore. With technology the way it is, it's hard to say that the time spent doing such activities are unforeseeable or not something that you can calculate or tell on a regular basis.
I feel like it takes me 10 minutes to boot up every morning.
Yeah, right. I have that problem quite often.
Maybe that's a DLA hardware issue.
We need to talk to our IT people about that. So maybe DLA would have that argument. But the wage statements. I always harp on this because it never ceases to amaze me when you're doing deals and you're going through diligence and you're looking at companies and looking at wage statements and ADP, Paychex, whoever is handling it, and you would think that they would be compliant and fine. Most of the time, they're not. Some states do have very specific, very cumbersome requirements for wage statements, and the penalties for technical violations of those labor code provisions or laws can be quite steep and can add up. So, looking at your wage statements and making sure that your wage statements have all of the applicable requirements with respect to the jurisdictions in which you're operating or you have employees is extremely important. Also, expense reimbursement. Know that different states have different laws with respect to expense reimbursements. Now that so many people are working remotely, something to pay very, very close attention to and to make sure that you are complying with applicable law. And then worker classifications. We have exempt, non-exempt issues, which Georgia will discuss in a minute. But with independent contractors, always a tricky area. I think one area to point out, or one thing to point out, there are a gazillion tests for independent contractors that each state and courts and agencies use to apply. The two main tests, the DOL's test for the FLSA and the NLRB's test as well, those are, but DOL is still in the process of kind of reining the test back to what it used to be. NLRB has already done it, but they're walking back the sort of the lax or the more lax stance that the previous administration took with respect to independent contractors, then going back to the more fulsome economic realities, weighing of all the factors, not highlighting any particular factor. So that is an area that's also under increased scrutiny.
All right, so what can you do to mitigate misclassification risk? I'm jumping in on the US a little bit here. I think the most important thing is just understanding what your company's appetite for risk is. If you're a startup that's looking to be sold, or you are a PE company that's eventually going to be exited, it could be that you take a more conservative approach to how you think about contractors, because that's absolutely something that will come up in due diligence in the event of a sale. If you're a large company, you may be able to absorb some of this risk, and frankly, you may just not be able to get W-2 employees everywhere you need them, so contractors might be a good option for you. Things like being careful about paperwork, ensuring that your agreements have applicable language, that this is indeed an independent contractor relationship, that you're not putting language in there that indicates that you're treating these people as if they are employees. They're able to manage, the means, manner, and method in which they perform the services. They're not on your org chart. You're not giving them, ideally, a lot of employee benefits. Of course, the contract alone is not definitive or determinative, so you're also going to need to consider the relationship as it exists. So again, are you really treating this employee, or this contractor rather, as part of your workforce? Are you, I lost my train of thought. Are you treating them as part of your workforce? Are you using them to perform the same or similar services to your actual employees? That's really a big watch out, and that is one that we're seeing scrutinized more and more by state authorities, so definitely something to look out for. And then, do you have a system in place for bringing on contractors? I often find that when we talk with companies, there are different people engaging different contractors for different reasons, and there may not be one holistic system for thinking about why you're engaging labor that way and who's in charge of it. So a few things to think about to hopefully mitigate risk.
And if you can, try to avoid hiring or engaging, sorry, not hiring, engaging contractors in California, Massachusetts, New Jersey, Illinois. Makes things a little bit easier.
Yes, that is absolutely true. The ABC test continues to exist in those places, and it seems to be growing in other jurisdictions as well. So watch this space. Another big highlight, many of you may know that the Department of Labor just published a notice of proposed rulemaking that would increase the minimum salary threshold for exempt workers from around $36,000 a year to $55,000, which is a pretty significant jump. The comment period is currently open. I think it is set to close on November 7th. That could be extended, as it often is with these proposed rules. Once the final rule is published, we expect there will be challenges to this. I have to say, I haven't heard a lot of people getting very up in arms about this yet, maybe because it feels very remote and unlikely that this may ever take effect, or we could end up with some sort of revised rule, but it is on the horizon.
And they set our expectations last year that it was going to go up to 88,000. So I think when they settled on the 57, people were like, oh, okay.
People are happy. People are relieved.
Sigh of relief, yeah.
Yeah, and even though that's happening, I mean, the comment by the DLA is interesting. Overtime protections would apply to 3.6 million workers. Well, you could also make the decision to raise pay, assuming that those people are validly classified as exempt in terms of the duties they're performing. It doesn't necessarily mean that overtime would attach. You just need to think about compensation and making some changes there. A quick whirlwind tour of a few other updates. I mean, I think just as we see inflation and cost of living just rising everywhere, a lot of states have increased their minimum wage. I mean, there are still so many states, including Texas, where we're at $7.25, but many states have doubled that and then some. Some states have also raised the minimum salary threshold for exempt workers. California and Washington were sort of first out the gate with this. There are others as well. New York has just raised theirs to, I think it'll be around $67,000 a year, which is pretty significant. I think they're already around 58, but they're going up to 67,000. So again, states are definitely taking the lead here in the absence of action at the federal level, although we'll see about that DOL rule. Some interesting new rights that are also being provided both to employees and contractors. There's these sort of proliferation of gig worker rights legislation in various states. Washington State as well as Seattle now extends certain benefits to gig workers. Although they're not considered employees, they can take advantage of certain state and local benefits, and that largely applies to the transportation industry. Fair work week laws, I'm sorry, one I did want to call out. Also, additional increased protections for freelancers in Illinois. This is a law that's coming into effect next year that will basically attempt to codify the terms that you have with your contractors. So they'll need to be in writing, they'll need to include specific terms, and typically you'll need to have a fixed term on how long you engage those contractors. So that's a pretty big one for those of you who have contractors in Illinois. Another thing is cracking down on wage theft. New York just passed a law that would make it larceny if you accidentally or deliberately fail to timely pay wages to your employees. So haven't said larceny since law school, I don't think, but I got to say it tonight. So. And then a little bit on transparent and predictable working conditions, moving outside the US very briefly. Another directive, the EU now has a directive that says within 7 days of hiring anyone in an EU member state, you need to give them written terms and conditions that include key things like their schedule, the rate of pay, any benefits they might receive, and in particular, if they're not what's called a predictable worker, if they're someone you engage on demand or only occasionally, including really specific language in there. It also does something interesting, which is set the maximum amount of a probationary period to 6 months. As many of you know, there's not really the concept of at will outside of the US. Probationary periods are often the only time you have to sort of terminate someone who's not working out for performance reasons without triggering a lot of notice and termination entitlements. So 6 months, it's not nothing, but there is that maximum period now. So it's just something to think about for those of you who have workers around the globe. All right, so now we'll move into more employee rights, talk a little bit about work-life balance and employee well-being. And again, I'm gonna try to move pretty quickly through some of these, but And please chime in too on this one if you want to as well.
I'm just confused about what does work-life balance mean?
Does it exist?
Is it a thing?
Will we solve that tonight? I don't think we will.
And this is why my practice stops at the water.
So this is a sort of a hodgepodge of U.S. and non-U.S. developments, but again, a lot of family-friendly and just worker-friendly developments in a number of states. I'll start with California. California always has a very active legislative session. Last year, they expanded the definition of family member under both family, medical, and sick leave laws to be pretty expansive. Basically, any blood relative or anyone you associate with a family member. So it's quite broad there. They also now require employers to provide 5 days of unpaid bereavement leave to anyone who is grieving a family member. Not the same definition of family member, very confusingly, but 5 days of unpaid bereavement leave. Illinois has also extended unpaid bereavement leave rights for a number of reasons, including related to a pregnancy loss, a failed adoption or surrogacy, a reproductive reproductive procedures that are unsuccessful and similar things. You can now use unpaid bereavement leave for things such as that, as well as to grieve other family members. So just extending those rights that touch in the family sphere. A couple other notable things. Illinois also has now passed, Illinois has also been very active, if you can't tell. They have passed what's called anytime leave. It's going to be 40 hours of paid leave that you can take anytime for any reason. It's a pretty novel concept. We don't really have this. Obviously, we don't have it at the federal level, and most states don't mandate any sort of paid leave for this type of reason. So that will take effect, I believe, next year. So again, that's 40 hours, 5 days a year. For eligible employees. And just something to note, a lot of states are now rolling out their own family and medical leave acts, and a lot of those are paid for by payroll contributions, Colorado and Oregon among them. So in this year, employers are now starting to pay into those funds, and soon after that, employees will actually be able to take advantage of that question.
Do you happen to know how to define eligible employees in Illinois?
Eligible employees for purposes of anytime leave? I think it might be everyone, but we can find that out. Yeah, no, you're fine. I don't know if there's a waiting period before you can take advantage of it, but we can find that out and let you know. All right, anything else that's interesting here? We talked about increased PTO and holidays, and I think outside the US too, a lot of flexible and remote working legislation has arisen, in part, I think, because of COVID. Just putting more rights around allowing employees to work remotely, giving them a lot of rights when they do in terms of expenses that need to be paid for. In a lot of countries, equipment and services that are provided in the course and scope of your work need to be paid for, reimbursed by your employer. In the UK and other countries, there's also just greater rights around allowing employees to work flexibly. So yeah, it's definitely it seems like a very worker-friendly environment right now. I know that's not always the case, but one more directive. It is actually called the EU Directive on Work-Life Balance, and this one was enacted at the same time as the EU Directive on Transparent and Predictable Working Conditions, and really aims at underscoring leave entitlements in various different capacities, including a mandatory paternity leave. It also has a requirement. All states are required to provide 4 months of parental leave to eligible employees in the EU. What this does is say that you can't split it. You have to give at least 2 months to the father or the non-birthing parent and 2 months to the birthing parent in an attempt to bring some equity to who's staying home with the baby, which is interesting. And then 5 days of unpaid carers leave. So expanding the circle of what are you eligible to take leave for, to maybe care for an elderly parent or another family member. So again, just the EU Commission has also been very active, and I think we'll continue to see more in that space. All right. Last thing before I hand it back to Todd and Kim. This has been a trend lately, again, in a number of European countries, but not just specific to Europe. We've seen legislation in Canada as well as some countries in Latin America around this right to disconnect. It's a little more bark than bite. Some countries require a specific policy. that some don't, but underlying it, there are a lot of carve-outs to this idea of disconnecting after you leave the workplace or when you're on leave. So really it's more guardrails and trying to be mindful of when you contact your employees. And those countries that require policies, I think the bottom line is, if you do have guidelines about when you can and can't contact someone, trying to stick to them to make sure you don't elicit claims. But we haven't really seen much litigation come out of this yet, so sort of remains to be seen if this trend is really growing. It's also interesting in a lot of places where you would think this would apply. We were talking to our colleague in France, and I don't think I realized that a lot of them are contractors. So I made some comment like, "Oh, you were online really late tonight. Like, how does this law apply to you?" And she said, "Well, it doesn't apply to me because I'm a contractor." So there's and I think in many countries, service professionals like lawyers and others may be exempt. So there are, like I said, lots of carve-outs that make this maybe not as scary as it might seem, but it certainly is the law in the books in certain places. So. All right.
All right. So the U.S. is also definitely moving in a more employee-friendly direction lately, even in some more unexpected places. For example, the Fifth Circuit's recent decision in was it Hamilton against Dallas County, raising the increasing or lessening the burden that people have to show of what an adverse employment action is.
Most of the circuits in this country, that was already the law.
But here we had 30 years they stuck with it, and then they overturned it.
20,
so.
yeah.
So
we won't be winning those 12B6s as much anymore.
No. The Supreme Court, of course, recently raised the standard for showing undue hardship in connection with religious accommodation requests. I don't know if anyone gets the EEOC news blasts. If you don't have the pleasure, they have been on a tear leading up to the end of their fiscal year. Their fiscal year ends September 30th, and they filed so many actions from August to September. I mean, it eclipses anything in the past few years that they've done. They just released their strategic enforcement plan. The issues that are on the strategic enforcement plan, they really do focus in on that. It's very important to them. So you get a charge, and it's related to an issue that's on the plan. Pay attention to it. They're also really, really, really honing in on reassignment as a reasonable accommodation. If you get a charge that deals with that issue, pay close attention. There's a circuit split on what the company's responsibility is in that instance, and the EEOC is pushing it really hard. So just be on the lookout for things like that. But I think the juiciest topic is non-competes and restrictive covenants and what's happening with those. I'm sure everyone has heard about the FTC's proposed rulemaking, which would essentially prohibit non-competes, except for in very, very limited situations in the context of a sale of business. The NLRB has also been making moves in this area, also taking the position that non-compete agreements are unlawful. They're also taking the position that other types of agreements between employers and employees that have a tendency to restrain the employee's ability to freely engage in employment after they leave a company is also a restraint on trade and unlawful as a chilling effect on Section 7 rights. They recently, I think last month in September, the NLRB filed an enforcement action against a company, a national company, both with respect to their use of non-competes, also with respect to, they had a training repayment agreement with the employees. The employees were trained on the job. If they didn't stay for 3 years, they'd have to repay a certain amount for the training costs. So the NLRB has filed an enforcement action against that company, and then move to the states. So a lot of states are also making moves in this area. Minnesota this summer banned non-competes. New York legislature passed a bill banning non-competes. The governor hasn't signed it yet. No indication that she won't. So likely non-competes will not be lawful in New York. rather soon. Colorado, of course, recently enacted a very strict non-compete law, has very strict salary thresholds. You have to make over a certain amount for to enter into a non-compete. You have to make over a certain amount to enter into a customer or client non-solicitation provision. There's also very, very strict notice requirements. You have to give a separate notice along with the non-compete in very plain language, telling the employee that that there is a non-compete. It can prevent their ability to engage in employment after they leave the employer. A lot of states are putting sort of like what we're accustomed to at the ADA, the 21-day consideration period, onto non-competes. 10 days, some states require you to allow an employee to review it for 10 days, some are 14. So you're seeing things like that more often. Even Texas, there was some traction earlier this year to redo the Texas physician non-compete statute. It would have capped the buyout, the buyout amount. Physician non-competes in Texas, you can enforce them, or you give the physician the ability to buy out of the non-compete. It capped the amount that you can set for the buyout. It was also going to set the time period at 1 year, and then the geographic scope would have been set. It's very limited, but based on the population of the county in which the physician is located. Nothing happening with that now, but definitely was something that a lot of people thought would successfully make it through this year. And then, probably most interestingly, is Delaware. Delaware has had a string of cases since last fall, chipping away at non-competes. They both in the context of a sale of business and in the employment context. There's 4 cases now. There's 3 on the slide, but there are 4 cases now. One came out last week. All of them took issue with the scope of the restrictions, particularly with the definition of competitive activity or competing business. The courts were very clear that they wanted to be able to see a very clear connection between the legitimate business reason underlying the need for this particular individual to have this particular non-compete. They also have now said that they're not going to blue pencil or modify non-competes if they find them unreasonable. And then last week, a court took issue with employers or companies using Delaware choice of law in employment-related contracts, including in non-competes. The judge basically said, a lot of companies like to use Delaware law, but just because a company is incorporated in Delaware, there's a transaction, it's governed by Delaware law, does not mean that it's reasonable to choose Delaware law for the choice of law provision in a non-compete agreement. And in that case, the employee was in Illinois. The court found that for relevant purposes, Illinois law was similar enough to Delaware law. We didn't have to make the decision, but anyway, it's out there now, beyond notice, that just because you're choosing Delaware law doesn't mean that a court will apply it. And also, I don't know that you still want to be or to choose Delaware law with the sort of the chipping away at the restrictions and the scope of the restrictions that you're able to get away with at this point. Oh, so just when you're thinking about, of course, none of us know what restrictive covenants will look like in 3 years, except they won't look like what they look like now. That's for sure. But I think in the meantime, it's really important to think about what's appropriate for the employee, what's appropriate for the jurisdictions that you're operating in. How does, administratively, how easy is it for you to have various templates that you can use in various states to ensure that you're complying with various laws? If it's not, and you're in 50 states and you want one template, you can't do one, maybe 2, you might not be able to do a non-compete. Maybe a non-solicit is more reasonable. I think thinking about things like that, also the restricted period, courts are taking issue with longer restricted periods. So I think really important to look at, what are you trying to protect? What's the legitimate business reason? How do you tie it to the person that's being asked to sign the agreement? I think
It's me.
Oh, it's you. Back to Kim.
There would be no discussion on employment law update without talking about discrimination and harassment. I do so much litigation. These are the areas that I'm litigating most of the time. The first thing I want to mention is the uptake in what the EEOC is doing. It's come back from the pandemic, from COVID. We are seeing enforcements increase. Their fiscal year just closed on September 30th, and the enforcement actions, or at least the litigation that's being brought in the discrimination harassment area, it's at a 5-year high. Most of it is focused on systemic discrimination and workplace harassment. There were 43 hostile work environments lawsuit that they brought last year, and almost 30 of those cases were brought on behalf of employees alleging claims related to sex and sexual orientation. So the EEOC is focused, and they told us in their strategic guidance that that's where they are going. They are also going back to the ADA. The number of ADA lawsuits nearly doubled during the last fiscal year, 48 disability-related cases, and a big area here is failure to accommodate mental impairment. So this is something to take very seriously in the interactive process as you're looking at what a reasonable accommodation is. The EEOC is targeted. I now want to move just very quickly to some Texas cases because, well, here we are in Texas, and it's always a different world sometimes. I'll first mention a case that was decided by the Texas Supreme Court. And whenever I see the Texas Supreme Court says it's a matter of first impression and it's an employment area, I'm definitely going to read it. But this is the Nihei case that arose under the Texas Commission on Human Rights Act. And as you know, TECRA and the ADA, the Texas Supreme Court has instructed Texas courts to really just follow federal law, follow the ADA in construing TECRA. Well, one of the issues that had not been resolved was this was regarded as a disabled case with a resident in medical school, and she morbid obesity was the issue, and she was able to get through the trial court and the appellate court by establishing that morbid obesity alone qualified as a disability. She said it would qualify under the ADA, should qualify under TECRA. The Texas Supreme Court said, no, that's not how we read it. So it's one of those rare instances where the Texas Supreme Court said, we're deciding this as a matter of first impression, and said that for morbid obesity to qualify, meet that impairment, that physical impairment that you must establish to show a prima facie case, there it has to be accompanied by an underlying physiological disorder or condition. That has to cause the obesity. Obesity alone is not enough to satisfy that requirement, and this did not go back to the trial court. The court made its decision as a matter of first impression, and it dismissed that case. It was over. It was done, so we now know that's the law of Texas. I will briefly mention the Crown Act, which I know most of us have read about or are familiar with because it had been before the Texas legislature for a number of years, was not passed. Governor Abbott signed it into law in May of this year, and of course it covers, hairstyles and issues in the workplace that we thought we may not have to address. Well, it is now the law of the state of Texas, and I'm just reading what's happening with employers and with schools, and there's still lots of controversy about the Crown Act. I don't think people kind of quite get that this is the law now, and you don't get to talk about, certain hairstyles or whatever, or at least kick people off the football team or say you can't come in the workplace with a particular hairstyle. Todd mentioned the Hamilton case. This is a very important case because we had done 20 years of ultimate employment decisions. I could write that summary judgment in my sleep based on an ultimate employment action, hiring, firing, leave, compensation, as we say, the biggies. I think that came in Dulles in like 1995. That was the law of the Fifth Circuit. That is no longer the law of the Fifth Circuit, and it now went back to the actual language of Title VII, adverse employment actions, and so you don't have to meet that ultimate requirement. There's some very interesting language by the Fifth Circuit in writing that opinion, and this is an en banc decision of the Fifth Circuit, because when it came up from the trial court, of course there was a 12b6 granted. You know, this was a policy in the Dallas County Sheriff's Office. How they ever thought they could get away with this? The men could have the weekends off and women couldn't. So it was clearly sex. They admitted, of course it's sex-based. It's like, yeah. But under that ultimate employment decision standard, the trial court had to dismiss it on 12b6. You know, scheduling on the weekend was not an ultimate employment action. It wasn't hiring, it wasn't firing. And the Fifth Circuit said, you know, that ultimate language, it is nowhere in Title VII, and how we have been using this for so long, we're not quite sure, but it came in line with other circuits that had ultimately found that, of course, it's an adverse employment action. And what you're looking at is, does the act complained of, the prohibited act, does it affect some term or condition of the employment? And that's what we are looking at now. The Fifth Circuit specifically said, we're not going to tell you what an adverse employment action is in this case, but we're just telling you what it's not. So there are some other important state statutes that we mentioned, and the big thing about those is that they are increasing protections for employees. There's a Vermont one, harassment and discrimination. You don't need severe and pervasive. Maine is increasing the limits on compensatory and punitive damages for intentional discrimination with certain employers, 14 or more, under their Human Rights Act. So again, I think you see the importance of looking at the particular state law in addition to whatever is under Title VII. Just very briefly, some additional requirements for Texas employers. This is HB 915, which requires employers to post notice to employees regarding the reporting of workplace violence or suspicious activity to the Department of Public Safety. Of course, it's the usual, it's got to be in a conspicuous place. English and Spanish is appropriate. Went into effect on September 1st, but the Texas Workforce Commission doesn't have to come up with the posting until March of next year. So we probably won't see any enforcement until we get what that posting is. And finally, I'll mention just the Texas Regulatory Consistency Act, which prohibited local governments from regulating certain employment standards, leave, hiring, firing. It was supposed to take effect. It did take effect on September 1st, but it was blocked by a Travis County judge under state preemption issue, unconstitutional. This matter is now on appeal. So.
And did we miss our 5-minute warning, or are we?
Oh, no,
Are we okay
I
on time? Okay, that's not so bad. 3
Been
minutes.
blabbing
Yeah,
away.
we're getting there.
All right. Oh, here we go. Sorry.
Well, yeah.
I'll tee you up.
Really, what that means is AI. So we can just talk about AI. And I can talk about this for. I'll be quick now, but I could talk about this for all day. I'm super interested in it. I think it's fascinating. I don't think enough people are talking about it in the employment context. So happy to discuss after. But just some things to, I think, quick things to think about when you're thinking about AI, and again in the employment context, is there are a couple of ways you can address it. One, the company's use of AI the tools that the company is using, screening tools. Are they using, automated employment decision tools to screen out candidates or to help source candidates? Are they using AI, or are you using AI for efficiency, productivity, to help improve performance, things like that? If you are, ensure that you are using it in a way that it's compliant, of course, with AI-specific laws. And in the employment context, there's one. New York City got out early, and their law relates to the use of automated employment decision tools in connection with hiring and promotion decisions. And there are some requirements that you have to meet if you are using such AI tools in a certain manner. The other thing to think about is that all of the laws that have been on the books for decades, all of the guidance, the best practices that we've talked about for years is still applicable. Just because you're using AI, just because you don't know how AI made a decision or created content or why, doesn't mean that you won't be liable if one of the laws that we've had on the books for years, Title VII, the ADA, the ADA, are being violated. Again, this is on every federal agency's top priority list. It is something that they are looking at. They are not waiting for new laws to be enacted that regulate the use of AI. They feel like the conversations with people from the FTC, the EOC, they all feel like their existing laws are sufficient to regulate the use of AI in the employment context. So that's one way to think about it, again, is how is the company using AI? But then the other way to think about it is how are employees using AI? Are you allowing employees to use AI? Are there generative AI tools that they have at their disposal? Have you trained them on how to use these tools? How they can, maybe they can use it to create a first draft, but they shouldn't be using it to create a final work product. Make sure that they're trained on confidentiality issues. If you put something in ChatGPT, it might not be confidential anymore. Intellectual property, all sorts of issues. So just, the companies are taking different approaches. Some companies are developing their own tools that employees can use that have firewalls that are protected, that aren't sort of let loose on the internet. Some companies aren't, and allowing employees to use things like ChatGPT. So depending on the extent to which you're allowing employees to use these tools, make sure that they're trained, that they're knowledgeable, and that they're using them in an appropriate manner. And they realize that at the end of the day, they're going to be responsible for their work product, not the AI. Are we still?
I think we may be over time.
Okay.
So we had a section on going global. We could probably spend a whole hour just on that. So in lieu of that, and so we can get our next act up here, I will just flag two of our resources. Some of you may know we have an amazing database for employment developments and events called Genie. It's free to all of our clients. If you're subscribed, amazing. If you're not, come talk to one of us after this. We're happy to get you signed up. One of the cool things is if you opt in, it will send you daily email alerts on different legal developments and other things like that, so you can stay up to speed. It covers the US as well as 44, 45 other countries. We also have our guides to going global that were just refreshed that talk about anything from employment to corporate formation to tax issues to IP. Those are all, you can Google that, DLA Piper Guide to Going Global, or we can send you the information that you need. That's 60 different countries. So lots of content available. We're happy to share it with any of you. Just let us know, send us an email. And with that, I think we will wrap it up unless anyone has any questions.